Joining us now is Danya Perry. She is counsel for Michael Cohen in Trump's New York trial, and this is her first interview following Cohen's testimony. Danya, first of all, thank you so much for taking the time. I know you've spent the whole day in court, so I appreciate it. I just wanted to start by asking you, how is Michael Cohen feeling about his testimony now that his portion is wrapped?
Would you believe I haven't spoken with him since we walked out of that courtroom, and I'm going to try not to, and I'm certainly advising him to stay off of media and social media. I can tell you how I feel, which is not just relieved and exhausted, but good. I think it was a great day for the prosecution, and I think the sum total of the testimony, which was over 25 hours, I think, in the aggregate, I think it all went well, and as you point out, is just of a kind, of a piece with the rest of the testimony in this case. So to take your language, you know, there's an old saw, if the facts are not on your side, pound the law. If the law is not on your side, pound the facts. If neither are on your side, pound the table. And I think we saw a lot of that from the defense over the course of the past week and change.
There was a fair amount of table pounding, including near the end of today, this afternoon, in this exchange between Robert Costello and Judge Merchan. What did you make of that? We know what their objective was, but what did you make of that and kind of the impact on the case?
Well, we had hightailed out of the courtroom in the courthouse by then, but from all accounts, look, this is also very much in line with what Michael has testified to and the reason why he did not trust Bob Costello. And so, as Judge Merchan apparently said at sidebar, the behavior bordered on contemptuous, legal term, and I think not overly surprising given what we've heard from the witness stand.
I mean, his objective, of course, was to add to the effort to discredit your client, Michael Cohen. Years ago, he waived his attorney-client privilege when it comes to Robert Costello. Do you regret that? Should he regret that?
I don't think there were any blows that landed. I think Michael testified exactly what that relationship was and why he stayed at arm's length from Bob Costello. And I think the jury saw that on full display today. So, no, I think Michael has been nothing but forthright with this prosecution team. Some of the, so-called aha or gotcha moments were given to the defense care of Michael Cohen. He is the one who first disclosed this Redfinch payment that you referenced in your opening. He disclosed that 4 years ago in his book. So there was no gotcha moment. He is the one who turned over his phone voluntarily to the DA's office, and that is where the defense got those, so-called, Clarence Darrow moment, text messages between Michael Cohen and Keith Schiller. So all of this has been, again, part and parcel of Michael Cohen providing information, trying to be cooperative, meeting with the DA's office dozens of times as he testified to. And so I think all of this is very much in keeping with, the top line. And the takeaway here is that he has made his peace with his admittedly checkered past and has decided to turn his loyalties away from Mr. Trump and towards his family, his country, and to be cooperative and to be truthful as of the time he made that decision. And he was also truthful about the many lies and mistakes he's made along the way.
To your point, he kind of volunteered, even during testimony, he wasn't pushed terribly hard on some of the specifics, including the $30,000. You're a criminal defense lawyer. I want to ask you about some of their strategies here, because they never cross-examined Cohen about a lot of parts of his earlier testimony, including the crucial Trump Tower meeting, as well as his visit to the White House. Why do you think they skipped over all those topics?
Well, I want to first say hats off to the prosecution here. I thought Susan Hoffinger did a masterful job doing what we call drawing the sting and front-loading a lot of that damaging information. And so I think there were moments where Todd Blanche was a very old friend of mine, and so I'm not going to say much other than he probably felt there was only damage he could do by going back to it and revisiting it. And so I think there was that. And I think that they really didn't want to touch a lot of the substance, a lot of the cross-examination related to collateral matters that really had nothing to do with the core facts of this case and the core testimony from Mr. Cohen. And so it's, I think, what you described as distraction, noise. You know, it's a sideshow, it's smoke and mirrors. It's what defense lawyers sometimes do, and I don't fault them for doing it. But they really didn't want to go too close to the actual facts and the testimony here, because as you pointed out, I don't know if it's 20 witnesses, I don't know how many witnesses corroborated, but it's any which way, both by documentary and testimonial evidence. And I think it was probably a smart move to stay away from a lot of that.
They did stay away from a lot. One of the things they focused a great deal of time on was this single phone call from October 24th of 2016, when they claim your client misremembered. And Michael Cohen testified that he spoke to Trump about Daniels, but the defense says that's a lie. Kind of feels to me like a small detail in a much larger fact pattern here. But do you think it was a strategic decision by the defense to kind of amplify this one phone call to try to make it into something bigger than it really is? Or why so much focus there?
Yeah, again, I don't fault them for that. It seemed like something that where they could elicit, you know, some inconsistencies or draw that out. And in fact, again, not a Perry Mason moment. This was a a minute and 36-second conversation. The jury heard the recorded conversation about Karen McDougal, where the substantive portion was, what was it, a minute. And so a lot was accomplished, and several other topics of conversation were also discussed in that one short recording. And so, of course, a jury is going to be able to look at that and say, yeah, a lot can happen in 96 seconds. I mean, the prosecution could, it's kind of an old trick, they could just make the jury sit there silent for 96 seconds, and they'll see just how long that is. So I didn't think that was a great moment in a substantive way, but it's certainly, you know, there's something to be said for courtroom theatrics and acting like you scored some big points. And look, the way some of the press reacted, people thought so just because there was that kind of performative energy. So again, I thought Todd Blanche did the best job that he could with what he had. And there was some baggage. There's no question. Whenever you have someone who's pled guilty as many times as he has, and who's admitted it as many times as he has, you know, you're going to have some moments. But all in all, I didn't think that October 24th call, you know, really was anything other than noise and a sideshow.
You kind of alluded to this in the baggage, and you know, Michael Cohen has voluntarily put some things forward, some things he has been pushed on. I guess the big question here is, should the outcome of this case rest on Michael Cohen's credibility?
That's not for me to say, of course, and certainly not during the pendency of this trial. There's a very attentive, very smart jury. I've watched them keenly. They are paying very close attention, and they are not missing a beat here. So ultimately, of course, this will be in their hands as soon as next week, and they will decide.
Tanya Perry, I know you've had a long day. Thank you so much for joining me this evening. I really appreciate it.
Thanks, Jen.